Good afternoon and welcome back to KW Property Management and Consulting's Community Association Best Practices monthly webinar series. I'm your host, Tim O'Keefe, an Executive Director and Partner with KW Property Management and Consulting. Since our last webinar on March 17th, the rollout of COVID vaccines continues to pick up pace. I read an article this morning that said 40% of all adults in America had at least one shot. I can tell you that as of this morning, I've had my second shot. While many other countries are seeing a spike in COVID cases, the US continues to administer vaccines to all those who want it. Here in Florida, nearly 25% of the population is fully vaccinated, up from 12% just a month ago. And Florida now has made vaccines available to anyone 16 years of age or older. In the US, Americans are feeling much more comfortable, but the CDC reports that the US needs to get to 75 to 80% of the population being vaccinated to reach herd immunity. Across America, we have 26% or 86 million people are fully vaccinated. So that's a pretty good start. Even with this positive news regarding vaccinations, community associations are still cautious about opening amenities. As we get started today, please take note of our poll questions. You should all be able to see a number of questions that you can answer. Throughout today's webinar, we'll share our poll results. Today, we will focus on the state of Florida and new laws being addressed by the state legislature for community associations. The legislative session is coming to a close this month, so it's timely to discuss what we can expect from the governor to consider signing into law on July 1st. I'm delighted today to welcome back two prominent association attorneys in the state of Florida. These gentlemen have been on my webinars over the past year. They always do a great job educating us. So let me introduce our panelists today. We're joined today by Gary Mars and Robbie Blanch, both well-respected shareholders with the Siegfried Rivera law firm. Gary and Robbie focus their practices on community association law. We will get their different points of view on today's topics. Welcome back, gentlemen.
Thank you very much. It's a pleasure. Thanks for having us.
Thank
and
you.
By the way, Robbie's a lot more respected than I am, so we'll give it to him. That's why he gets to wear the tie.
I'm sure he'll agree with that. If he takes himself off mute, he can tell us how much more respected he is than you.
Robbie, you're muted.
Robbie, you have to take us off mute so we can hear how respected you are.
There you go.
You got me now?
Yes, sir.
We do.
I was just being respectful.
Well done. Well done.
Thank you. Also joining us today is Rick Dingle. Rick is a Regional Vice President for KW Property Management Consulting. Rick's responsible for the effective management of dozens of condominiums in South Florida and brings a very hands-on and practical approach to property management. So welcome back, Rick.
Thanks, Tim. It's a pleasure to be here, especially with the two esteemed counselors from Siegfried Rivera.
Thank you. It's good to see you, Rick.
It's good to see you, Gary. It's been too long.
Pleasure.
So, Gary, let me start with you. So we're going to talk about law and the state legislature and how it all works. So when does the Florida legislature session begin and end every year?
Well, we're in session now, and what ends up happening, just so everyone understands, is we're in what ends up typically happening is we're in a period where laws are being debated and presented. And what usually ends up happening is that the legislature is in active session now usually through the end of April. And then the legislation can go into May based upon the timing of things. And then what ends up happening is that the laws are introduced. They're taken out of what's called session laws, out of the committee side of things, and they're actually introduced into the legislature. They are voted on, and then the issue really comes down to whether or not it hits the desk of the governor, whether the governor is going to sign them into law or not, or that's usually a big issue. So, we're not getting any, there are a bunch of different laws right now that are being considered very broad, all over the place, laws that have consideration going on in Congress right now, in the state legislature. And, but, they will typically be signed usually the end of May, the beginning of June, and there's usually a July 1st start date, but it doesn't necessarily have to be that way. That has been predominant, that a July 1st is a typical start date for most of the community association legislation.
And Gary, the state legislature tackles many different industries with a wide range of laws that need to be debated and established each year. Who determines what's going to make it to the floor to actually debate on these and try to get pushed through?
It's got to come through committee, and then the committees have a vote, and then based on the committee vote, it gets introduced into the appropriate branch of government for their discussion and debate, and then the voting, and then again, once it becomes a draft, it comes out a draft and it goes into and through the legislature, and then the actual law will hit the desk of the governor for the governor's review. But it goes committee to the legislature to the governor.
I always oftentimes wonder who's sitting in the background writing all these thousands of pages worth of law that comes into play for the legislature to read and then vote on during the course of the session, because there's a lot of work that goes into this.
So typically, I mean, it's not the greatest answer, but it's probably the most appropriate, is that it comes through lobbyists. Typically lobby their appropriate governmental representatives. The representatives typically sponsor legislation, which you commonly and often hear about, and they're the ones who are actually typically the champions who bring the stuff through the legislature. And there's co-sponsors of bills, and those bills get discussed and debated, and then if they pass the appropriate checks, then they get put into law.
And a lot of the bills can ride on some other industry's bill too. So we can be affected by insurance lobbyists, by banking lobbyists. But talk a little bit about lobbyists for the community association industry, because there are lobbyists out there that work on behalf of everybody on this call that's part of an association.
Right. So look, there's various different ways to slice that. There are for-profit business lobbies. Like, for example, I know that a lot of you guys, or some of you guys, management may have dealt with, for example, commercial laundry contracts. Commercial laundries typically have limited impact through 718 and 720, because years ago when the statutes were being drafted, there were lobbyists that were around that were pro-commercial law. I don't mean the company, I'm talking about the concept, the field commercial laundry contracts. So they're not included in much of the other vendor type legislation. So that's why their agreements are a little bit of a standout, just using them as an example. So there are various different lobbyists that are around that champion their industries. And they may not have anything to do, to your point, some of the legislation that comes up may be in a different direction completely. Like, for example, towing, just picking on something, is a completely separate piece of a statute, but it does have an impact on community associations, because it mentions community associations in that legislation. So there is crossover legislation, which is the way it's typically referred to. I mean, this has become much more civic than anything, this conversation, but there's crossover legislation, which sometimes and often does have impacts on community associations.
Okay, great, thank you. So that gives us a little bit of background how law comes into play. And then Robbie, for you, if you could address something a little more specific to the industry. Every year we see laws that get adjusted slightly for our industry. And how would you describe community association law as a matter of importance to the state legislature? And over the last 5 years, what do you believe have been the most significant changes in community association law, good or bad?
Well, I mean, that's a pretty broad question. I believe that, having practiced in this area for about 20 years, what I've been most impressed with is what appears to be the growing importance of the community association industry to the legislature. The types of laws that you would see enacted at the earlier stages, for instance, of my career were much less and much less significant in my recollection. Thereafter, with the advent of additional access through social media, through the internet, other stakeholders and groups that have assisted community association stakeholders such as unit owners and board members. All of this has expanded knowledge, and with that expansion of knowledge, there have been more and more laws proposed and submitted through the legislature for consideration that would impact and ultimately get adopted to impact the community associations. Most recently, I feel that those that have been of great significance have been those laws that expand electronic meetings, electronic notification, digital record keeping for the owners to have access to all of that information, whereas before there was no mandate. Less than a handful of years ago, the legislature did enact legislation that made it mandatory for associations in excess of 100, condominium associations in excess of 150 units, to have records, their official records online, to notice meetings and post notices of those meetings online. Minutes of board meetings and unit owner meetings had to be posted. That may be tedious to our clients, but the overriding interest here has been more transparency, more information to be available and accessible to all the owners. And of course, we've got the electronic voting, which in the last year, given our pandemic, has proven to be very vital to associations that in effect have had a legislatively supported means by which to have unit owners legally and properly vote. Because even though we've been doing what we're doing right now, and that is having virtual meetings in most of our condominium and homeowner associations, we've kind of been like winging it. We've been using Zoom or other platforms such as that, but the question becomes, is that really a meeting? Are those owners there toward quorum or not? Are the owners able to vote? We know board members can attend virtually and in a electronic or even telephone conference setup, and those owners, pursuant to the statute, strike that, those board members, pursuant to the statutes, do count as being present toward quorum and being able to vote and participate at the meetings. But there is no similar law in effect for unit owner meetings. So had it not been for the advent of the electronic voting laws that were adopted a few years ago by the legislature, this past year we would have been unable to have many elections and vote on many amendments to condo documents or the use of reserve funds, etc. The usual things that owners can vote on electronically. So that, I believe, those electronic digital type laws most recently, and furthermore, in light of the pandemic, I think have proven to be very significant. And I'd be on the lookout for more of that. I also think that, if I can just add one more, the emergency powers aspect of the statutes, both in condominium and homeowner associations and in co-ops, has given us, especially in the last year, an opening in order to enact at an association level a lot of these specialized rules or the suspension of having to have meetings, all of which is allowed by those emergency powers in those three acts, condo, co-op, HOA, and that has given us the opening to allow more flexibility in how we do business in the condos. I do feel that in the upcoming legislative sessions, you may find more clarification on those emergency powers to apply them to these types of situations, whereas before there was debate among practitioners with regard to whether or not those emergency powers were contemplated to apply to a pandemic type situation as opposed to a post-hurricane or post-property damage type event. So I think those two on a more recent level have been very relevant.
So Robbie, my next question was actually, is there still an emergency order in place? Does it still exist, and how long Well, one of the questions from one of our participants today, Mary Ann in Deerfield Beach, wanted to know if it still exists, when does the order expire?
Yeah, I'm not aware of any expiration of those orders, quite frankly. There have been modifications of the governor's order and even of the mayoral orders, because you got to look at each municipality on its own, right? The city of Miami had its set of orders. Broward County had its set of orders. Palm Beach had its set of orders. Each municipality within those counties and the mayors of those municipalities enacted their own orders in addition to what we had at a national and at a state level. You know, while they've been chipping away at them and loosening them up, I do believe that we're still under emergency orders that we can arguably use to afford us the ability to tap into that emergency powers of the respective community association laws that govern us in the state of Florida. You know, and then of course, I don't know if you plan on getting into it later on, but you know, we kind of have to have a lot of these rules and modified rules for community associations because of the potential for liability that associations may encounter in the event that they completely eliminate all of these restrictions at this point in time, because of the fact that you still do see some of the governmental agencies, if we want to call them that, right? The CDC, namely, making recommendations and guidelines as to what people should be doing vis-a-vis social distancing, wearing of masks, et cetera. And that also has some type of interplay into what we should be doing as community associations and as counselors for community associations, what we should be advising our clients. And I'm specifically referring to Senate Bill 72. I don't know if you have it on your agenda to get into that, Tim, but
it's coming up in just a minute, so I'll come back to that. And so, Rick, I want to ask you a question from a practical point of view. How have you seen boards respond to the emergency order when making decisions for their properties?
Yeah, and that's a good question, Tim. I think across the board, we've seen boards work within the emergency orders, and to Roberto's point, certainly utilize electronic means as necessary to hold board meetings, still to conduct business. Same thing with annual meetings. In some cases, those meetings were postponed, which was available through some of the executive orders. But we are seeing, similar to the population, where there is a large outcry from residents to reopen things, reopen the pool, reopen the gym, reopen the sauna. And a lot of those things are beginning to take place. And I think, unfortunately, boards are starting to succumb to resident pressure to reopen some of these amenities. And we are seeing that as well across the board.
And we'll get to that. We'll have some more discussion about reopening and the best way to do it. But that's a great response. But I do want to turn to Senate Bill 72 for Gary and Robbie to talk about this. And I'm going to share my screen because the gentlemen were kind enough to share a brief presentation and some talking points. So gentlemen, could you explain the purpose of the bill and the impact on community associations relative to this bill? And I hope you can see my screen here, the Senate Bill 72.
Yeah. So if you take me to the next slide, perfect. You know, frankly, the bill was enacted to provide a level of protection from civil liability for businesses within the state of Florida. And there's another aspect of it which I believe exceeds the scope of our discussion that applies to healthcare providers. But focusing on the business aspect of it, you know, the bill does focus on protecting entities and business entities or corporations, not-for-profit, such as our community association clientele, from civil liability in connection with damage, injury, and even death that might arise in connection with COVID-19 or what may be proven to be a COVID-19 infection at one of those business entities or the facilities operated by those business entities. The bill does require, and this is all a new law that was enacted by the legislature in quick fashion, but it requires that the plaintiff advancing the lawsuit must state with particularity the allegations in their action as to, why it is they feel that the defendant should be liable for the COVID-19 liability that they're seeking to pursue relief for. The other thing that is required in addition to the plaintiffs having to plead with particularity is this affidavit from a physician. So, the legislature now is requiring that this plaintiff have an affidavit of a licensed physician, in effect drawing that link between the claims being made by the plaintiff and the business entity. So, that's a pretty high threshold that needs to be met by the plaintiff in pleading their case. That then pushes it into the association, or let's call the association the business entity in this case, if we're speculating that associations are the defendants of these cases, hypothetically speaking. The association would then need to document or prove or establish that it has acted reasonably and that it has adopted reasonable care in protecting against these liabilities. So that is a very what some would suspect to be a very easy threshold for the associations or the business entities to achieve. In the event that the plaintiff fails to meet those first two standards, the pleading with particularity and the affidavit, then they cannot proceed any further. If a judge determines, let's assume that they do meet those two initial elements or conditions, then the judge would have to determine the extent to which the defendant, in this case, let's say hypothetically speaking, the association, made a good faith effort to substantially comply with authoritative or controlling government-issued health standards or guidance at the time that the cause of action accrued. If the judge determines that the business entity did, then the case goes no further. If the judge determines that the business entity did not, then the case could continue. And in order for the plaintiff to win, in effect, they need to document by clear and convincing evidence that the business entity is guilty or acted in a grossly negligent manner. So those are the elements walking through this bill as to the high standard that needs to be met in order for a business entity such as an association to be considered liable for COVID-related claims that may be filed by a plaintiff. So the next slide
Robbie or Gary, if I could ask this question around this, how does a business judgment rule overlay on top of something like this? Because the business judgment rule is that we're in all good conscience, good faith, good judgment, we're making the right decisions for the community. And we thought we did. Someone got sick. Am I liable personally? Am I liable as an association board member?
Well, the business judgment rule is part and parcel to the discussion. The focus should be, Tim, on the board in this case. Let's talk specifically in regard to associations, to ensure that they have and are enforcing reasonable rules based upon what is the requirements of the government entities at that moment. So there is leverage for the boards to make decisions based on that. I think Robbie and I clearly agree that one of the things that shouldn't be happening is some sort of radical or extreme decision by a board of directors to stop implementing all COVID-related restrictions that were currently in place. That type of reaction is not probably falling under good faith or reasonable, to use another term that should be applied. So when you go back to the business judgment rule question, you do have some ability to make decisions based upon the needs and requirements of your association. To apply the business judgment rule, number one, You need to have a thought-provoked understanding of what the requirements are. You need to have a board of directors meeting, most particularly, where owners have the right to participate in it. So again, I'm not saying anything should be done outside of that. And I don't want to confuse, going back to something Bobby said, which may be taken a bit out of context. I don't want, the concept about emergency powers, I think was a question that came from you, Tim, originally, but we are all operating under those restrictions. So mixing a couple things in, whether or not their emergency powers apply or not apply, we do have certain obligations to ensure that, the good and welfare of our community, and to ensure that our ownership and our residents are being properly taken care of. And I mean, that's part of our obligation as a board, not a direct obligation. I'm not saying you're going to have liability if somebody, God forbid, gets COVID or something, but we have a reasonable obligation to ensure, and management has an important role in that as well, to ensure that these communities are being properly administered and the proper processes and procedures for everybody's best interest. So coupling all that together, again, as we're sitting here today under this legislation, it would be prudent for boards of directors to consider, what makes sense under the current existing local, state, and federal requirements. Certainly a look toward the CDC would be one way to go, to ensure that the board is following some sort of prudent path. And the business judgment rule, also along with your documentary requirements and your statutory rights under the condo or the homeowner association statute, will be also useful in guiding you as to establishing those rules and modifying those rules as you're moving forward. A lot of legal speak just to say you need to be reasonable. You need to make sure that you're acting in good faith. You need to take into consideration as the barometer what the governmental requirements are.
Do you either one of you gentlemen know, has this been challenged yet in court?
I mean, this law just came out. I mean, so
yeah,
I don't. It is very new. It is very, very new. So I haven't seen any challenges on it at this point. Again, just to make Robbie's very good point again, what it is doing is it is minimizing any kind of liability for damages brought by somebody who thinks that they were damaged as a result of somebody's actions or inactions, lack of actions involving, the unfortunate reality of COVID-19. So it was something that, yeah, go ahead.
One of the questions that we got from one of our participants today, David in Del Rey, wanted to know regarding Senate Bill 72. He said it pretty much allows pools to open with a warning sign about abiding by CDC requirements and putting out sanitizing wipes. What about inside though? Can we open our gym with a sign warning about social distancing and mask use and not end up getting sued? And do we need to add UV lights and special filters to the AC system?
All of that is the greatest legal answer in the world, and that is it depends. Because there is all of this. How much of this is really an exact science, Tim? If you mentioned it earlier, if you start researching a lot of this, you'll start getting a bunch of different answers. And if you start seeing what's happening across the country, across the state, across the county, or the world, you'll be seeing any number of different conduct taking place, whether it's right or wrong. But if we use some of that as a gauge for what we should be doing, then from that we extrapolate what would be considered reasonable. And I think acting reasonably and taking reasonable precautions is what we want to be in a place to be able to justify, right? So for instance, if no gym in their right minds is open right now, which we all know is not the case, right? But if no gym were open and one of our clients wanted to open a gym, I don't think they can make a good case that they'd be acting reasonably. But we all know that with varying degree and different types of protections and precautions and protocol, gyms are open for business. We know larger gyms are open for business. Even some smaller gyms are open for business. What spatial considerations are taken into account? What cleaning measures and disinfectant measures are taking place? What capacity restrictions are being implemented? All of these issues, I believe, need to be taken into account if we're referring to the gym, for instance, and a board that might want to loosen up restrictions on the gym use of the amenities. I think perhaps there is a good case that it could be done depending on certain factors. But as management, you guys know that you'll go out there, you'll find some type of healthcare authority, whether it's the CDC guidelines or some other type of authoritative body that would give you some type of guidance as to what should be done within reason. And once we can latch on to that, then I believe we should have enough, especially as it relates to Senate Bill 72, to be able to justify the actions we were taking. So I think it's relative. The answer to the question is one of relativity and how your amenities and your property can accommodate some of what the objectives that the board or the membership may have in reopening.
So Rick, what are you saying from a practical point of view as far as associations bringing back community gatherings and what size is typically allowed? And then we'll circle back with the attorneys on what starts to look reckless and too big. But what are you saying as far as board members making decisions on gatherings?
So Tim, most recently, and it's just been in the last couple of weeks, some boards are beginning to put together meet and greets, and they're trying to keep it to a very small amount, no more than 15, 20 people, maybe 25. People have to be socially distanced, people have to wear their masks, people have to practice all of the things that the CDC is requiring for safety under COVID. But I would tell you that that is a very, very small amount of our communities going in that direction. Generally speaking, most communities are still not dabbling in community events. They're not having meeting rooms open or any of those kinds of things. People are still cautious in that way, but they are doing things outside, as I mentioned. So these couple of associations that are getting together, they're doing it in wide open spaces where they've got, big pool areas or big terraces. They're setting up tables, if you will, where they are properly distanced. There's sanitation that's taking place on a regular basis, but everything is being done outside. If anything's happening, it's being done outside.
And so from a board's perspective in making decisions, Robbie and Gary, does it kind of wrap around what might be considered recklessness as far as whether or not association or individuals liable?
Well, it's a good question, but as I don't know if Robbie hit it, but the standard when it jumps, meaning the Senate bill and the legislation, when it jumps from not having liability to having possible liability, using the word reckless, it's the best way to explain what gross negligence is. That's the standard. So once you are grossly negligent, you are now possibly much more liable for the damage that has been caused. So you said it very well, Tim. So look, Robbie was using the best example. There's no way to give an absolute blueprint as to exactly what you should or shouldn't do. There should be a discussion probably between management, the board, and council. I would wrap in your council because some of this stuff probably would be best guided by your association council and some consult with that council. But again, we're not seeing generally meeting rooms opening at this point. We're going to get into a moment, another smaller piece, but an important piece of executive legislation having to do with, how do you even check to know whether or not somebody has been vaccinated and your rights to do that? And there really aren't any way to do that. So a lot of associations in calling are saying, I'm getting into the practical. Hey, Gary, how do we deal with this problem? There's no way that we could confirm that everybody coming into the meeting room or a social event happening, that everybody has been properly vaccinated at this point. And the answer is you can't, because there's no ability to do that. So the associations have evaluated, again, for purposes of their occupancy, for purposes of their staff, for purposes of their cleanliness, that they don't want to start opening this up yet. There's too much variable, and I'm not trying to take a position in any way medically, but there's too much variable still out there with regard to the state of this virus. And a lot of associations say, better to be safe than sorry. And, that's how it is. But then you do have, which many associations have, we do have, several associations that are more open up everything and let's get this thing done, or keep everything closed. And I think, I don't want to assume anything, but knowing Rick and knowing Robbie, I think we would probably all venture to say that may not be the right way to handle this. The right way to handle this is to go back to that trying to establish a good faith process where you're being reasonable based upon your actual geography of your building, the layout of your property, the makeup of your population. I think all of these things need to be taken into consideration with some level of prudence.
And so when you really get down to it, we're just talking like, hey, break it down to me. I'm like a second grader, so I can understand it. How much advice would you give to a board as far as being practical, taking common sense approach to limit the amount of liability that you would have under Senate Bill 72? I mean, clearly this is to protect the association and not make you wide open. So what advice would you all gentlemen give relative to a customer of yours, a client that says, so how aggressive can I be, or how protective do I need to be still?
Well, the advice I've been giving is, baby steps, take it in stride. A year ago, there was no toilet paper on the shelves. It was Armageddon. The world was ending, and zombies were walking in the streets. And slowly but surely, we've been, learning more and more and more. Now you go to the grocery store and there's not this sense of panic. You get reports supposedly that, surface to individual contact may not be that transmissible with regard to the virus, supposedly they're saying now, and this is the CDC. You start getting the advent of the vaccines and growing populations becoming vaccinated, and of course, what impact is going to happen. And then to a point Gary mentioned earlier, with all of this being said and done, and with everything that we're learning in a very narrow window, by the way, within just 1 year, we're starting to loosen up, right? So we know that our children have been able to go to school here, for instance, in the state of Florida, pretty successfully, but they're wearing masks, they're observing a lot of the CDC recommended protocol, and we are slowly but surely returning to some semblances of normal living, albeit not 100% there. And I believe things are going in a pretty decent path or trajectory. Of course, I suspect this is only going to get better, and that way, it is perhaps feasible to start loosening up in a very pragmatic, practical, measured approach. And this is the counsel that I've been giving clients. I've, for the most part, almost entirely, it's been well received. And even though there is this desire for things to be lifted and 100% return to normalcy, people also recognize that there's an equally vocal polar extreme that wants to keep things very tight, very restricted. And so you've got to have to strike these balances, especially in these larger community associations that we tend to also work with, to make sure that we are doing the right thing for the greater good of the residents, of the staff, of the ownership, of the guests and the invitees that are going to be visiting this property. And I think that this bill we've been talking about gives us, both management and the lawyers, it gives us something in writing that we can put in front of our board members to justify this level-headed, slow approach to opening up, right? Not the immediate ripping off of the Band-Aid, but a slow and cautious return. I think encouraging them to do it in a practical way would establish that we can preserve the exemption from liability that Senate Bill 72 is providing, whereas if we act a little bit more radical, then are we flirting more with that grossly negligent standard that you or what you characterize as reckless? Because that's what we don't want our boards to do. We don't want them to be grossly negligent or reckless, because that equals potential liability. And by the way, it equals potential liability for which there may be no insurance coverage. And that's another thing that your boards should be cautioned about, right? Let's be measured, let's be careful, because in the, God forbid, we do have some type of claim asserted against us, what is our insurance coverage going to be? So that's something we want to be careful about. And I don't know if we're going to get into it, Tim, or not, but this step-by-step process on the slide that you've got up on the screen now makes reference to the governor's most recent executive order, which is the governor's mandate, I guess, that no public business, no state entity, and no business entity that participates in state funding use or implement or require what have been commonly now referred to as vaccine passports. And so, of course, to a point that Gary was mentioning earlier, of course, we've got some of our clients that are saying, well, what if we start saying all the vaccinated people can, do whatever they want because they're vaccinated, right? So, can we ask people to prove to us that they've been vaccinated because that would allow them to do whatever they want in the community? So now we start having to evaluate as lawyers whether or not we are the type of business entity contemplated by this executive order, or are we not? Should we still use and interpret some of the guidance provided in this order to restrict the use or the concept of vaccine passports within our communities or not? So these are all questions that we are now having to grapple with as community association lawyers.
But the tail end of that, just to finish, is that the general view has been it's maybe a little too early for us to know how to handle this because there is not either enough legislation or enough interpretation of this legislation right now to know that. So we would guide our clients to be cautious, and we would not present to them that they should be taking any of these steps that, due to the lack of clarity, that's not typically your best prudent legal advice. It's to be cautious and take this back to Robbie's comment, step by step. And let's do this gradually based upon your particular environment of your property. That would be the best way to go.
So there's going to become a bigger issue. One of the questions that Gail from Boynton Beach is asking is, are associations legally able to restrict amenities to residents who affirm they are fully vaccinated? So there's those that are and those that aren't. And my advice would be still treat everybody the same. It's, even if you're vaccinated, what I've read is you're 95% protected. It doesn't mean you still couldn't get sick. If you do get sick, it's supposed to be less severe based on the vaccine that we all have gotten. So I think you have to take good practical measures when you make those kind of decisions. And until there's more information out there from the CDC, I think we should all take a conservative approach. That may not be a popular approach, but I think being conservative is still a better, safer approach right now.
Right. And then you run into, which is I got a call the other day from a client. The conversation was a very smart, very well-intended president of an association raising the point that we have some members of the community who haven't been vaccinated. We have others that have gotten one vaccination. And then we have the issue about we have several different types of vaccinations with different effectiveness. So it all, and then none of it's 100%. So what's the bottom line is it's a mixed bag. So, err on a precautionary level and make sure you apply, of course, everything across the board. You can distinguish different silos of application. That is not, the context of how the entire community association operations operate. They have to be done in across the board in an even manner. So the best thing to do is, take it step by step and evaluate it based upon your association's needs. But evaluate, the point needs to be, you need to have those reasonable conversations and rules and demonstrate good faith, because again, we don't want to open ourselves up for unnecessary liability.
And I go back to, look, board members you're all volunteers. And this is starting to get into some pretty heavy stuff when you start talking about liability. And right. So it's rely on your association attorney. Your property manager is not your attorney. The property management company can't be your attorney. Rely on your attorney. When in doubt, just protect yourself and be safe so that you don't find yourself into a messy expensive lawsuit somewhere down the road because you have one of the owners that's going to take advantage of the situation. So just protect yourselves best possible and talk to your attorneys. That's the best advice I could give. Not that anybody asked me for advice, but that's what I would give.
I think Robbie and I would agree on that. Talk to your lawyer.
And
hopefully
Rick,
it's
100%.
Rick, let me ask you a couple of questions have come in. The nice thing about what's happened with the pandemic is we've moved away from what about my support animals, and we're talking about pools now. So pools have replaced pets. So it's the new P word to me. So with pools, we've gotten a couple of questions about, what is the best way to handle gatherings at the pool as far as pool size, and how could we better handle guests? How should we handle guests coming to pools? Like, what are you seeing out there from a practical point of view, how we're managing those types of questions?
Yeah, and that's a good question. And I would say to you that pools are open, but I would also say with heavy underline and bold, with a lot of restrictions. So they're restricting the number of guests that can be at a pool, and the guest has to be present with the unit owner, that they make a reservation to be at the pool. Maybe it's 2 or 3 hours, that they social distance, maybe in some cases that they bring their own chairs with them and sanitize their own chairs and take them with them when they leave. So there's been a lot of restrictions that's been put on place, not only on pool decks, but also in pools that are reasonable, that make a lot of sense, and that are still in keeping with everyone trying to be safe. Now, the hard part of that is always when you've got rules like this, how do you enforce those rules and how difficult it is to enforce those rules? But it has to do with a lot of communication. It has to do with everybody rowing in the same direction, understanding that we're in a pandemic. We're trying to do the best we can, but there are going to be restrictions. And those restrictions are tight, and we ask everybody to abide by those restrictions. And also, be a good neighbor. If you have a pool reservation for 3 hours, be kind enough to pick up and leave at 2 hours and 50 minutes. So there can be some sanitation take place, and someone coming in can still enjoy the pool. But there are heavy restrictions in place, and it's being enforced.
And so if we can shift a little bit different direction, Gary, you touched on this, so I'm going to come back to it. You talked a little bit about being able to require somebody to show up with, show me your vaccine card. Did you get a vaccine or not? Can a board require people to report once they get a vaccine, or is that all protected?
It's not permitted by the executive order that Robbie was indicating. Has restrictions on that. It's actually the owner signed it. It's very recent. The public policy is against it. There's liability issues which go into the medical arena and medical information that comes into play, which in condo and homeowner associations is an issue. In other words, is it medical records that are being violated that can't be shared? So there's various different levels of reason why the answer is you can't request somebody to establish or prove that they have been vaccinated. So, and then there's, again, I'm not trying to get into the science of it all, but then there's that added variable that you mentioned, Tim, which is even if you were vaccinated, this is not, it's not like there's a 100% guarantee to anything. So, it's to establish rules and regulations or allow people, opportunities against somebody else because they have or they haven't. I think it raises so many different levels on so many different grounds and legal basis. So I advise, obviously, that it cannot be done.
And so, Robbie, I want to come back to you. We talked a little bit about the use of technology this year has really changed the way we look and think about associations and communication that we all use for board meetings and just general communication, committee meetings. Is there anything that's being contemplated by the state legislature around more specific law for Zoom meetings? You touched on it earlier, but can we expect to see something get put in front of the governor this year to sign into law what the use of technology, the expansion of technology actually means for boards?
You know, that's anybody's guess. I'm not aware of whether it's in any of those pending bills, frankly, and even still to what extent they are going to make it through the various revisions that end up happening. Gary, I don't know if you're aware of any of the pending legislation that might have any of that.
I've seen some of the session laws just in raw form, and there is some movement, not particularly on there is some movement with regard to both the expansion of certain rights, emergency powers, other things, as well as communication and electronic transmissions and things of that, which I think are all a fallout from what we just recently went through. But I want to caution, I don't, and I mentioned this to Tim in preparing, you know, these laws haven't even, you know, they haven't processed properly yet. So I hate to start making reference to particulars only because, you know, I don't, in these types of sessions, if something doesn't get passed, I don't want anybody to unfortunately rely on draft legislation or bills that haven't been converted into law yet. So, but there is a variety of different issues that I think are being presented, which are COVID takeaways that are in front of Congress, the legislature right now. I'm sorry.
So Barry's asking a question. He said, hasn't section 617.0721 been the statutory authority to have remote members meetings? And is this different than the 718 provisions allowing board members to attend the meeting remote?
No, but listen, guys, that's why I was saying before, I don't want to, and Robbie, I know you probably want to answer very quickly, but I don't think we should be concentrating on because I think that popped up when we were talking about, emergency powers before. The ability for the association to do much of what it's doing is couched in either 718 or 720. And there's emergency powers as well that apply, but I think most of everything we're doing is not even falling into emergency powers at this point. It's based upon our obligation to maintain the property and all the other rights that are afforded to the association, both based on its documents and in other provisions of the statute. So, you know, I don't see there to be a problem with that as long as it's done correctly. I'm sorry, Robbie, go ahead.
But in addition to that, it's important to note that while our associations are 617 not-for-profit corporations, the community association statutes preempt the method by which meetings are to take place and those types of formal protocol as to how business is to be conducted. And there is authority for that was put into 617 by the legislature that says, you know, yes, these associations are not-for-profit, but to the extent that a not-for-profit corporation is a 718 or 720 or 719 association, then you need to defer to those chapters as to whatever it is that those chapters govern. And then those chapters do specifically govern the manner by which meetings are held, quorum takes place, members can vote, board members may vote. So there is a cross-referencing to some extent that needs to take place with regard to the two, let's assume you're a condo, you'd have to reconcile how 718 does gel with 617. But where 718 has ventured to legislate, then you must defer to 718 and disregard the provision of 617. And that's specifically stated in 617.
So another question that came up from Gail relative to kind of what we can expect coming out of the session this year. Do you expect anything relative to rentals and how rental policies are going to change? Are you hearing anything about that?
I don't recall seeing anything on that concept. I mean, that is almost, entirely based upon your documents and amending documents. I mean, with the exception of like evictions and things of that nature, which has obviously had restrictions due to, legislative impact, but I don't recall seeing anything on any changes to the terms on rental restrictions. I don't recall seeing that. I mean, there may be something coming in through, not through, either the condo or the homeowner act dealing with short-term rentals or things of that nature. I just don't recall seeing that at this point.
Okay. So we've got a number of other questions that have come in. So,
can I before we get there, I just wanted to maybe raise one other point. One of the other elements of this is enforcement. And that's been, something Robbie and I have been dealing with just an enormous amount. You have, enforceable rules in play, and you have the unit owner who's going to ignore them. And then the question then comes up about, can we fine and do we fine? And, we have that whole discussion, and are we permitted to fine? And again, it's generally our view that you can fine if you obviously go through the proper process, which would be the board and then the grievance committee process, which we know is a bit arduous. And whether or not that makes sense when you have somebody on a Tuesday not wearing a mask, whether or not 20 days later or 14 days later by mandate, you're going to be addressing it through a fine or a grievance committee discussion or a restriction of use, which would also be dealt with by the grievance committee. So, the general position on this is that probably the most appropriate redress of those situations are letter writing or even contact. And I hate to put the property manager in that place, but a proper and respectful conversation to the owner explaining or the occupant, what the issue is and why we're enforcing the issue tends to go a very, very long way. And I would suggest also that management, and we've done this for a number of our clients, we actually drafted a couple letters for management to use, but certainly KW knows how to do this as good as anybody. But getting out a couple, letters, a warning letter, a ban letter, and then having counsel follow up in the worst case scenario is probably going to be your most effective way to achieve compliance. So my general comment is, and I think Robbie agrees, I think we talked about this, but I really probably wouldn't clog up the process with fines and grievance committee over these types of things. I think it would probably be best equipped. I mean, the purpose of this is not trying to collect a dollar amount as a penalty because somebody's not wearing their mask as required. It's more to see compliance, with some level of imminency, timing, and to have the person comply so we don't have to have these issues and have other unit owners either feel uncomfortable or unsafe. So I just want to throw it out there because, I think that is a very common discussion. And one of you used a great word, I think it was Rick, and that is, I would ask everybody if we were a little bit more neighborly. I'm not trying to make a public service announcement here, but I think that would go a long way also. Some people have different levels of obvious sensitivity to these things. And so I think we just need to be respectful, especially if you're living, there's a reason it's called a community association and not a single family association. And that is because multiple people are using the same spaces and we have to be respectful.
And so if I could jump into a couple of questions that came in because we're coming up on top of the hour. Robbie, Robert and Coco asked if we could speak about term limits.
Yeah, Robbie, I like Coco. You answer the Coco one.
Well, term limits, there was the term limit established in the Condominium Act with regard to any board member that serves for more than 8 years, or let's call it a consecutive term of 8 years. Initially, there was some debate as to when those 8 years started. We all know there have been legacy board members in many of our condominium associations. And so there was, an argument that those individuals, in light of the law that passed a few years ago, having served more than 8 years, were not eligible to serve. There was a division of condominium declaratory statement. I think it was the Apollo declaratory statement that initially created an argument that the prior year service did count against the board member, but then the division kind of did like a flip-flop. They said, well, no, it doesn't count anymore. We were just kidding. Now it's whatever happens after July of 2018. which was the effective date when that bill became effective of Chapter 718. So we start the clock counting on the 8 years, July of 2018, and then once we get to the 8 years from that point, if there are any board members that have been serving for 8 consecutive years, they may be, being the operative word, ineligible. I say maybe because the statute also provides that if 2/3 of the owners voting vote for that director, then that director is not term limited. Also, if there is no opposition to the directors, then that director may continue to serve. And if there is no election, of course, that director may continue to serve. So those are the term limits as it relates to condominium associations from a legislative perspective. You know, the HOAs, at least those that I represent, don't tend to implement or establish on their own term limits, but I'm suspecting that the question, unless I'm missing something, is directed more at the statutory term limits imposed by the legislature back in 2018.
And I think that's helpful because I know in prior years when we would talk about this, there was uncertainty if the start date was 2018 or back to when you got on the board. So it seems like it's more clear now that if you're going to start counting 8 years, it's from 2018. So it takes you to 2026. And if you're still on the board in 2026, 8 consecutive years, God bless you. So
yeah, we've kicked that can down the road a few years from now.
Yes, absolutely. So I'm going to ask another couple quick questions and then we'll wrap up since we're past 4 o'clock and you gentlemen have been kind enough to give us all your time. So Gary, Mary Rose in Fort Lauderdale wanted to know, can board members vote on association issues or maintenance items via email and ratify the action at the next board meeting?
So there's no mechanism for voting via email. It doesn't exist. So it's unfortunate. It's not there yet. So and I'm not saying it's not a common practice, especially when there's some level of urgency or a quick decision that needs to be made. But so if you're asking, there's no legislative ability and no documents would even allow that because it would be in conflict with the statute. So the way to do it would be to do it at a board meeting. And I appreciate that, board meetings, we don't want to sit in board meetings all month long, but, the approval process is to be done at a board meeting. The ratification concept is when you do something on a imminent or emergency basis by vote. In other words, you have an emergency board meeting, which is a less than a 48-hour board meeting, or you have a board meeting that it has been noticed and you add an emergency item onto the agenda, which wasn't previously there when it was posted. So those two circumstances, if there was a vote to approve something, either at an emergency meeting or at a meeting where an emergency item is added, the next meeting, there would be a notice out. That next meeting notice would contain that issue, and that issue at that meeting when you would ratify. So the concept of doing it, outside and getting some sort of either verbal or written, vote via email and then ratifying it, I understand it is a process that is used, but it's not supported by those statutes.
Excellent, thank you. And
well,
Rick,
the statute specifically says not to vote by email, though it does allow you, to Gary's point, the statute specifically allows board members to communicate by email, but it goes a step further and says you cannot make a final decision. You can't vote by email. So, and that applies to condos. So don't do it.
How about HOAs? Can HOAs decide things on email?
I take the position that they cannot either. Historically, before the legislature clarified the communication by email, I was even more conservative because there was research we had done as to, and drawing analogies to like municipal governments that have to operate under the sunshine and whether they can use email or other type of communication. And what it boiled down to was if the speed of the communication reached closely to like a conversation, then it would not be feasible. And so we know that these emails and the speed with which we exchange these emails, and then of course we've got texts, can be akin to a conversation. And engaging in those conversations, I used to equate that with having a board meeting that isn't properly noticed, to which unit owners or homeowners are not allowed to partake in or to be present in. And that went against the open meeting concept and the right of owners to participate in the board meeting process, to at a minimum know what's going on and be able to voice their opinions on agenda items. So before the legislature provided some clarity, my go-to response was, don't communicate in emails at all. Now I can be more aggressive with the condos because the legislature gave us that out, right? They told us specifically, you could communicate via email, board members, just don't vote via email. They said that to condos. I don't believe they said that to the HOAs, but I still would stick to a similar approach with the HOAs.
Okay, we're a few minutes past the hour, so I will wrap up. I'm going to ask each of you all the same question. It's the kind of answer I get. So Rick, I'm going to pick on you first, so we'll see how quick on your feet you are. So as we wrap up today's discussion, what have we learned in 2020 that we didn't think possible a year ago?
Well, certainly that we can still run business, we can still conduct business, and we can do it in the electronic age. So due to COVID, we weren't able to meet. We weren't able to, when I say meet in person. We weren't able to meet in person. We weren't able to do it the traditional way, but I think it's taught us that we are able to still conduct business. We can do it electronically. Hopefully at some point when vaccines are, the norm for everyone and this thing is in the past, we'll get back to meeting in person. But I think it did show us all a new way of doing business and that we can use technology and we can still make things happen.
Great. Robbie, what do you say? What do you think we learned this past year that we had no idea a year ago could happen?
They'll keep making toilet paper. I was impressed at how human nature, how human beings can put aside, at least the experiences I had, right? I can only speak from my experiences. And I'm sure people might disagree with me, but I've seen overwhelmingly people do the right thing. Those people that maybe at the beginning of the pandemic would tell you, I'm never going to wear a mask, put them on. They put them on because they felt it was the right thing. They felt it was a neighborly thing to do. And in the last year, in most of the condos I represent, and I'm sure managers and board members may disagree with me to some extent, but my experience has been that for the most part, overwhelmingly, people complied. And of course, there are some outliers, but people complied. And I think that was people doing the right thing, which we see happen oftentimes after and during catastrophic events, such as the one we're living in now, and we were definitely living in for the past year.
And Gary, you get the final word on this.
Well, I have a few quips, but I guess maybe I shouldn't. But I would say I'm surprised how much I like Peloton, because I didn't think I would like Peloton that much, and how good I am at conducting myself at hearings in underwear. That's another good one. But listen, I would tell you that I think probably, and I say this more in the context of associations, the resilience of everybody. There's always the exceptions, but for the most part, people have modified, they've been patient, like we joke, all the time, about, your voice, your mute is on, your mute is on. Everybody's gotten very comfortable, and I think that they've been, for the most part, in the context of community associations, I think everybody has shown a certain degree of patience. I would hope that everybody continues to do that, and we understand that, most people do, that there's different degrees of everything, and to be to assume some tolerance with regard to that and resiliency. So we're seeing it in legislation. I think we're going to see it in some of the new laws coming out. If they pass, I think we'll see that. But I mean, going forward, I think there will hopefully be a new breed of how we function and operate. And I the context, I think, of a community association is that it's not an exact anything. It's how it's designed anyway. But to remind people that, and to ask people to actually apply that in current time, it's nice to see. So I would say everybody should keep trying to get there and keeping an open mind and working together. And I think it's going to end up, I think all of us are going to end up being better off at the end anyway.
Great. Well, thank you. So each year we're anxious to see what new laws get passed as the legislature session comes to an end. More importantly, we want to understand how the new laws impact the daily operations of community associations. Our panel was fantastic today. Thank you, gentlemen.
Guys, just so you understand, Tim, we always do, once these legislative changes come into place, on our website, siegfriedrivera.com, that we will have all of this outlined and available to anybody who wants to queue in. So that information will certainly be available shortly after the legislation takes hold.
Excellent. So my sincere thanks to all of our listeners and registrants today. Today's session is recorded. You can watch this broadcast again or share it with a fellow board member. You can find it on our website at kwpmc.com, or you can also find it on our KWPM TV YouTube channel that we've created. I want to sincerely thank our panelists, Gary Mars
and
Blanch with Siegfried Rivera, and Rick Dingle, our Regional Vice President with KW Property Management Consulting. We're looking forward to having you join us again next month for the Best Practices in Community Association webinar series on May 19th. From all of us at KW Property Management Consulting, thank you for making a difference in your communities, and remember to be respectful of your neighbors and be protective of them and you as we continue to fight this pandemic. Thank you so much. Look forward to hearing from you soon.
Thank you, guys. Appreciate it.
Thank you so much.
Take
care.
Bye-bye.
Bye-bye. Bye.